afternoon, my name's Letitia Stocker. Welcome to my case presentation on Elmslie Ors versus the Federal Commissioner of Taxation. This case involves 4 taxpayers and raises 2 main questions relating to the operations of capital gains provision. The courts were to determine if shares were allotted to each taxpayer after capital gains provisions were introduced. Were they done so under a contract formed before capital gains could be applied? And what was the true cost base of the shares if the applicants had not acted at arm's length? Our taxpayers. In 1967, Mr. Valder commenced a stockbroking firm as a sole trader, and approximately 6 months later, Mr. Elmslie came on board and formed a partnership with Mr. Valder. They called the business Valder, Elmslie and Company. The business continued to operate under that name until August 30th of 1985. During this time, we had 2 more partners join, Mr. Moore in 1974 and Mr. Moyes in 1980. All partners were members of the Sydney Stock Exchange. To truly understand the facts of this case, it's important to be aware of changes in legislation. Prior to April 1984, the rules relating to a stockbroking business were that it must be run as a sole tradership or partnership, and 100% of owners needed to be members of the Sydney Stock Exchange. In April 1984, regulations changed, allowing corporate membership as well as up to 50% ownership for non-members of the stock exchange. This is also when foreign investment was first allowed, with a total of 15% for a single interest and up to a maximum of 40% for total foreign interest. In late 1984, the foreign interest allowed increased again to 50%, with an announcement that further reviews would be made in 1987. The most important change that occurred was on the 20th of September 1985, when we saw the introduction of the capital gains tax provisions come into operation under the Income Tax Assessment Act of 1936. Reviews of foreign acquisitions did take place in 1987. The Foreign Acquisitions and Takeovers Act of 1975 further relaxed rules allowing stockbroking firms to be wholly owned by foreign entities. Late in 1984, after the initial changes allowing foreign investment in stockbroking firms, the taxpayers began discussions with an investment manager of JFA, Jardine Fleming Australia, an Australian subsidiary of a Hong Kong merchant bank. The bank was owned by an Asian trader and a UK investment company. At this stage, nothing progressed, so in April 1985, the taxpayers met and agreed to set up a company, Valder Elmslie Limited. They hoped to have the company set up and ready to take over the partnership by July 1985. Shortly after this, in May of 1985, JFA made an offer to pay $400,000 for a 50% interest in the partnership, and to later in time pay 5 times the average profit for the remaining 50% ownership. On the 12th of June, a press release was issued announcing the intention to establish a joint corporate membership of the Sydney Stock Exchange between JFA and each of the individual partners of Valder Elmslie. The new firm was to be called Valder Elmslie Jardine Fleming Limited. On the 17th of June, Mr. Moore acquired a $2 shelf company, which subsequently all 4 taxpayers and the managing director of Jardine Fleming, Mr. Smith, and Mr. Grubb, investment manager of JFA, became the directors. A general meeting on the 25th of June occurred to change the name to Valder Elmslie Jardine Fleming Limited. They also agreed to increase the share capital. A heads of agreement had been carefully compiled, and the taxpayers and the representatives of JFA signed the heads of agreement on the 28th of June, next to the words "the agreement." The transactions within the heads of agreement required the approval of the Foreign Investments Review Board. Mr. Moore wrote to them on the 4th of July and applied for the new company, Valder Elmslie Jardine Fleming Limited, to be a corporate member of the Sydney Stock Exchange. He also applied for a trader's licence for the company. Both applications were granted in late July. Valder Elmslie and Company ceased trading on Friday the 30th of August, and the new company commenced trade on Monday the 2nd of September. Although the Heads of Agreement was a very comprehensive document that had been drafted with care and consultation, there was still Clause 20. Clause 20 stipulated, "This Heads of Agreement is subject to the signing of a formal agreement as between the partners of VE and JF." The formal document compiled of 3 documents: a deed, a shareholders' agreement, and a purchase agreement. The deed outlined the agreement about incorporating Valda Elmslie Jardine Fleming Limited, as well as the details of the share subscriptions of $75,001 shares and monetary consideration from Jardine Fleming Australia to each of the taxpayers. The shareholders' agreement made provisions to ensure boardroom parity between the directors of Jardine Fleming and Valda Elmslie, as well as providing details of the future purchase of the remaining 50% of shares to be at a later date of the 31st of December 1990. The consideration for those shares was to be 5 times the average annual tax earnings of the amalgamated company. Other clauses were included for if the situation should change where the government policy or legislation would prohibit further acquisition. The last document, the purchase agreement, was a deed for the sale of Valda Elmslie to Valda Elmslie Jardine Fleming Limited for the value of the assets within the business. These 3 documents, interestingly, bear a signature dated the 12th of September 1985. However, we know that they were not executed on that day, as the lawyers who drew up the documents did not send them to the applicants to be signed until at least the 17th of September. On the 20th of September, the new secretary of Valda Elmslie Jardine Fleming returned the partially executed documents to the lawyers. It was understood that the rest of the documents would be finalised and executed once the Foreign Investments Review Board approval had been received. Evidence given in court seems to be inconsistent about the timing and who signed what and when. The Foreign Investments Review Board approved the transactions on the 25th of October 1985. 3 days later, all directors of the new firm applied for their allotment of shares. JFA had 300,000, Valda and Elmslie both had 75,000 each, and Moyes and Moore had one less, being 74,999, as they each received one when they opened the shelf company. A directors' meeting on the 7th of November saw the allotment of shares, and they also executed copies of the agreements and they were exchanged. During the meeting, someone said to backdate the agreements to the last date of the drafts, being September 12th, noting that this was before the introduction of capital gains tax. A further condition regarding the requirement of the Foreign Investments Review Board approval was also handwritten on each document, effectively making the agreements conditional. In April 1987, changes occurred allowing 100% non-member ownership, and the Foreign Acquisitions and Takeover Act also relaxed, allowing stockbroking firms to be wholly owned by foreign entities. This meant JFA could acquire the other 50% shares of VEJF much earlier than anticipated. JFA made agreements with each taxpayer. Subsequently, Mr. Valda and Mr. Elmslie each sold their 75,000 shares to JFA on the 24th of July 1987, and Mr. Moyes and Mr. Moore sold their shares in August of 1987. The Commissioner viewed the capital gains as assessable in the year of sale, being the financial year ended 30th of June 1988. Each taxpayer objected to the amended assessments on the ground that even though the shares were allotted after the 20th of September 1985, they were not subject to capital gains, as they were allotted under a contract made prior to that date. Each applicant objected to the amended assessments and requested that the Commissioner refer the objections to the court. All 4 taxpayers agreed to be heard together. The first question that needed answering was, when were the shares acquired, or were they acquired under a contract that was prior to the 20th September 1985, or was it after that time when they were actually allotted? If the shares were to be found that they were actually allotted under a contract prior to the 20th of September, this would exclude them from the capital gains legislation that was added in the Income Tax Assessment Act 1936 in 1985. Section 160L specified the application of the capital gains provisions. The taxpayers disposed of the shares after 20th of September 1985, namely in 1987. This satisfied Section 160L1, and each taxpayer was also an Australian resident, satisfying Section 160L1A. Under Section 160L1B, the Commissioner argued that the shares were allotted on the 7th of November 1985, therefore subjecting them to capital gains. The taxpayers contended that the shares were allotted reported on the 7th of November. However, they argued that this is where Section 160U3 came in. This stated that where the asset was acquired or disposed of under a contract, the time of acquisition or the disposal should be taken to be the time of the making of the contract. The Heads of Agreement was executed on the 3rd of July 1985. The time of acquisition of the shares, therefore, according to the taxpayers, did not satisfy Section 160L1B. The argument that developed by the Commissioner was whether the Heads of Agreement had immediate contractual force, and if so, was this the contract that the shares were allotted under? It was agreed that the formal allotment occurred in response to the shares application made on the 28th of October 1985, after receiving the approval. Furthermore, it was accepted that the Heads of Agreement expressly stated it was subject to signing of a formal agreement, even though the taxpayers' behaviour showed that they had intended to be immediately bound by the Heads of Agreement. The Court accepted that the taxpayers acted in such a way that they intended the Heads of Agreement to have immediate contractual force. The Commissioner did not concede, saying the important question now was when the shares were acquired, and that the words in Section 160U3 under a contract should be narrowly interpreted to confine to the immediate empowering instrument. The Heads of Agreement was found to be the background document which gave rise to the later applications for the allotment of shares. The applications formed the contract that the shares were allotted under, not the earlier agreement which was said to be preliminary, so therefore could not be the contract where the shares were allotted. The Court agreed with the Commissioner that the shares could not have been allotted under the Heads of Agreement, as a further contract was required to directly affect the acquisition. Part 3A applies to the shares acquired on the 7th of November 1985 and taxes the net capital gain derived on them. The question now was, did the taxpayers deal at arm's length? The Commissioner inserted a cost base of $75,000 for each parcel of shares. The taxpayers argued that the Commissioner should have applied Section 160ZH9C of the Income Tax Assessment Act 1936, because when determining a cost base where dealings have not been conducted at arm's length, the consideration paid by the taxpayer may be greater or less than the market value at the time of acquisition. The Commissioner argued that the transaction was at arm's length and no one individual was in a position to dominate the company. The Court disagreed and said that the question was not the power of each taxpayer against each other, but the power that they had against the company as a whole. The Court found that the transaction was that of each individual director and that they imposed their decisions onto the company. The Court found in the taxpayers' favour that they did not act at arm's length. The cost base of the shares were calculated to $3.60 rather than $1. The Court ordered that the amended assessments should be set aside and readmitted for reassessment on the basis that the shares acquired had a different cost base. Having regard to this decision, the Court also ordered the Commissioner to pay the taxpayers half of their costs. We now refer to Division 104 of the Income Tax Assessment Act of 1997 for any legislation regarding capital gains, as Part 3A has now been removed from the 1936 legislation. Specifically, Section 160U3 of the 1936 legislation was rephrased in Section 104-10(3)A. The Federal Court has held that the contract under which an asset is acquired or disposed is the final contract that changes the asset's ownership and it's necessary to disregard any earlier contracts. This is important for us to know, so that when we advise clients in the future, we can make sure that they understand what contract it will be that will possibly trigger a capital gains event. Even though this case is more than 30 years old and the legislation that was used is no longer in use and has been revised, this case is still important today, as many judges still refer to it regarding the terms under a contract, as well as talking about at arm's length transactions. It has helped guide better definitions describing our legal principles. Thank you for listening to this presentation on Elmslie Ors versus the Federal Commissioner of Taxation. I hope you have found it interesting and enjoyable.